Hi, welcome to the second half of the Courses and Copyright in the Time of COVID session. This is the recorded version of a session offered on August 26th through Minitex. So the main focus on this is for online resources that you can use for teaching, and we are focused primarily on users in the state of Minnesota, but of course anybody else is welcome to look at this. I'm also focusing very much on United States law. This does not apply outside the United States. Hi, I'm Nancy Sims. I'm the Copyright Program Librarian at the University of Minnesota. I have a law degree and I'm an attorney as well as a librarian, which is why I have some things that might be helpful for you to know about this stuff. Let's move ahead. So this second part of the session, the first part of the session was on focusing on things that copyright is just not an issue at all. You don't really have to worry about copyright. So it was things like public domain materials and open license materials. That's the other video. Go look at that one if you're interested in those. Now we're talking about issues where copyright is definitely going to be an issue. These are materials that have copyrights. You want to use them. You want to know how you can use them in an online environment. Let's make sure we're all on the same page and talk about first, what rights does a copyright owner own? Well, the copyright owner has roughly 4 rights under US law, and this is spelled out in Title 17 of the United States Code, Section 106. Copyright owners own a bundle of rights: the right to reproduce or make copies of their work, the right to distribute their work for free or for paid, the right to control public performance or display, and using things in classes is usually a public performance or display, and they control the right to prepare derivative works, so translations or adaptations of their works. If you own the copyright, these are the rights you control. So if the copyright owner has all of these rights, what rights do people who aren't the copyright owner have? Actually, if you're not the copyright owner, you have almost all the same rights. They're just a little bit more circumscribed. So if you're not the copyright owner, you might be able to make copies. You might be able to distribute copies. You might be able to publicly perform or display the work, and you might be able to prepare derivative works. Why might you be able to do those things? Well, one, the law often provides times when you can do those things. One area where the law says you can make copies, you can distribute copies, etc., is fair use. Fair use is part of United States copyright law, and pretty much what we'll be talking about from here on out. But there are some other places where the law actually says you can do this. So there are other exceptions in copyright law. One of the ones that is most useful for instructors, but unfortunately doesn't translate to online teaching, is that there is an older exception in the law for using things in classrooms, and it's called Section 110(1) of the Copyright Act, and it says that if you are at a nonprofit educational institution engaged in face-to-face instruction with your students in a classroom or similar place, you can show them anything. So you can play a movie in class, you can read a book aloud to your students. Those are public performances, but they're absolutely allowed by law at a nonprofit school in the US. As I said, unfortunately, that does not translate online. It doesn't immediately cover online teaching. If you want to show things to your students online, you may have to rely on fair use. But just to be clear, fair use is only one of many times when the law says, yes, you definitely can do this. Another example that has nothing to do with teaching is if you compose a song and record a song and you release it as music that people can listen to, you literally cannot prevent other people from making cover versions of your recorded song in the United States. If you release an album and somebody wants to cover one of your songs, you can't say no. They do have to pay you. Even if they give away their cover version for free, they still have to pay you. But this is called a compulsory license. The law just says, yes, cover versions are allowed. Cover versions that change things enough aren't covers anymore. Those are derivative works, and so those can be things where you might need permission. There's always border issues. The most important issue, well, maybe not most important, but something to keep in mind about copyright law is you can also do things with other people's works because there's sometimes you want to do things with other people's works that are not on the list of things that copyright owners get to control. And this is more in private life, a little bit less in teaching, but the illustration on the slide is 2 teenagers sitting against a wall, and they're outdoors somewhere, and they have a set of headphones with cords, and they've split the headphones so that each of them has one headphone in one ear, and they're listening to music together. So nobody has made a copy of whatever music they're listening to. Nobody has given anyone else a copy here. This is not a public performance or display because only they can hear it, and they're not changing it, so it's not a derivative work. Some people might say, but so they're listening to the same, two people listening to the same song and only one of them has paid for it. So that feels like a copyright problem, but they're not doing any of the things that copyright owners get to control. So it's not a copyright problem. And this is actually why linking in the previous video, why linking to things that are publicly available online is not a problem, is you're not doing any of the things that copyright owners get to say yes or no to. When you link to something, you're not making a copy, you're just saying it's over there, go get it yourself. So lots of rights for people who aren't the copyright owner. Keeping all of that in mind, even if you own the rights or even if you don't own the rights and you still just have some usage rights to some materials that you're interested in using, contracts and subscription licenses can and do override those statutory rights. So you may sometimes have subscription resources that you are not allowed to use as class resources. This is going to be unusual, but it does sometimes happen. And if you have institutional subscription resources, somebody should be telling you about this. One concrete example of this almost everywhere is Harvard Business Review. You can subscribe to the database. Any individual at your institution who has subscription access can read individual things, but if you assign a particular piece as a course reading, you're supposed to pay separately, and that's part of the subscription contract with HBR. So that's an example of where normally you paid to access the database and everybody can read it, and you might be able to make a copy or not. You know, normally contract law and normally copyright law would control, but when you make the contract can override copyright law. So you can sign away. I just said you have all these rights. Even if you don't own the copyright, you have all these rights to use. You can sign away those rights, and sometimes we do. Yeah. Another thing to keep in mind as we're thinking about, what copyright law allows you to do. Copyright law may allow you to play some music in your course video, but hosting platforms can also set their own rules about what you can post that may or may not directly reflect the law. So for example, if you post your course video with music to YouTube, it's possible you might get a takedown notice. So this picture on screen right now is a screenshot from when I got a takedown notice when I posted a video to YouTube. This is a video about fair use. The song I was playing in this video is there's a version of Pretty Woman, the song by Roy Orbison. There's a version that was performed by Two Live Crew, was the subject of Supreme Court case in which they said the Two Live Crew version is okay, is allowed by law, is a fair use. Two Live Crew's rights holding organization tried to take down my YouTube video. I said no. I said I'm allowed to use this. I disputed the claim. But it's worth noting that YouTube, when you post things on YouTube, YouTube might take them down. In actually this particular type of claim saying this has a copyright, this is still within the bounds of statutory law. This is part of the Digital Millennium Copyright Act. It's notice and takedown process. YouTube also has some private deals with content providers. So sometimes when you post something to a platform like YouTube, and this is true of many other platforms as well, they may choose, just because of a separate private deal, something you don't have it's not in the law, they may say, okay, so-and-so claims this is their video, now they get to put advertising on it and claim the ad revenue. That's just something that happens with a hosting platform that doesn't necessarily reflect the state of the law at all. In fact, some of these YouTube things that get taken down under the statutory process don't really reflect the law, because fair use allows me to do this. So things may get taken down. Things may happen because of the platform's deals that don't necessarily line up with copyright law. This is one of the reasons why for instructional content, it's actually a really good idea for institutions to have their own video hosting platform. If you have something where your institution can host the videos, then you can control when you take it down. So somebody, a student wants to post an assignment and YouTube takes it down before you have a chance to grade it. That's kind of a problem. If you have a place where the student can put it that's not on YouTube, that's always a good idea. It's nothing wrong with YouTube here. It's a great solution for many things. Some version of this video will probably end up on YouTube, but there's some sort of private ordering stuff in the background here that may be surprising and may not line up exactly with what your understanding of things like fair use. So all that said, let's talk about fair use. Not going to talk about the details right away. I'm going to talk about fair use rhetorically. Fair use is, I say, the jello of copyright law. It's a jiggly wiggly piece of the law. It's something that people can be quite uncomfortable with because basically nobody ever agrees on whether something's a fair use or not until after it's gone to court. You can get publisher representatives and they'll say, oh, that's not a fair use, and then you're going to get a librarian who says, yeah, that is a fair use, and hopefully you don't go to court about it. When you do go to court, the librarians have been winning a lot lately. Google, HathiTrust, some other cases. So public interest uses are often okay, but people are often all over the map on whether they think they are fair use or not. So I'm using Jello as a visual analogy here. There's a green and white Jello mold on the screen as an illustration here. Not everybody likes Jello. Totally understand that. If you don't want to deal with this flexible, uncertain, wiggly thing, then you want to be back in the world of things where there's a subscription or you have permission or all of those things. That's kind of the other part of the video. Everything from here on out is going to be a little bit uncertain ground, but that's good. It's meant to work that way. So fair use is the jello of copyright law. There are some people who will try to sort of suggest that fair use is a kind of a shady part of the copyright law. I've heard people say, oh, fair use, that's sort of tolerated infringement. So I like to read the actual text of the law, which is now on screen. And at the beginning of this paragraph, it says the fair use of a copyrighted work, and I'm skipping a bunch in the middle, but at the end it says the fair use of a copyrighted work is not an infringement of copyright. And they highlight certain types of fair uses here. Just because something's not on this list doesn't mean it's not fair use, but these are things that are especially likely to be fair use. Criticism, comment, news reporting, teaching, including, this is in the statute, teaching, including multiple copies for classroom use, scholarship and research. Those are all things that are quite likely to be fair use. And one of the reasons fair use is flexible is because we can't always anticipate ahead of time what kinds of uses people might want to make for criticism or comment or teaching or research. For example, people have been using, now that we have a bunch of digitized text, a lot of people are doing computational text analysis, throw a huge bunch of digital text into a computer and have it analyze how people use words. And you can learn all kinds of new things that way. That's not something that you could have predicted was going to be a research area 20 years ago when, I mean, not 20 years ago, many more years ago than that, but the last time fair use was updated in the statute. So fair use is meant to be flexible on purpose so that we can react and do new things as new disciplines develop and as new technologies develop. It's kind of, I kind of like it, it's kind of cool. Some people seek specific guidelines about fair use. So you may say, just tell me what is fair use and what is not. And there are plenty of people who will tell you what is fair use and what is not. There's a couple of sets of guidelines that were produced by congressional committees. There's also some guidelines that came out of Cornell University in 2006. Those are because of a lawsuit that was at Cornell University. There's also guidelines you'll find random people online who are happy to tell you exactly how much you can use, and that's fair use. Most of those are wrong. When you're looking for exact guidance about how much is fair use and how much isn't, you're asking the jello, which is meant to be jello, which is meant to be a little bit unstable, to act like concrete. You're asking for fair use to be exactly predictable. And the whole point of fair use is that it isn't exactly predictable. We want to give people some flexibility to have the law move in new ways. So I'll talk a little bit more about guidelines when we talk about how much is fair use, but people give, if people are giving you exact yes and no answers about fair use, consider that likely to be suspect information, unless they're referring to specific court cases, in which case they might be giving you better information. There are some court cases where you can reach a fairly clear conclusion afterwards. So that's sort of my concept of fair use. Fair use is great, it's good, it's meant for public benefit, it's meant for teaching, scholarship, and research, but it's on purpose flexible, and you have to deal with the wiggliness, the uncertainty with the flexibility. That's how fair use is meant to work. So how do you deal with the flexibility? Well, oh, actually, pause, back up. The big issue for this whole video is fair use different during COVID. There's flexibility, there's uncertainty. Is COVID the kind of thing that flexibility is made for? Maybe. COVID may be the kind of thing that fair use flexibility was made for. Maybe, because I don't know yet, but I've been part of a group that has put together some suggestions around this. Fair use is often looked at by courts as an outlet valve for public interest issues, for things like satire and criticism. So one thing that has come up in relation to the public interest in the past has been an idea that fair use may be more likely if there's an extreme time pressure. It may be more likely that you can go ahead and use something without permission if there would not have been time to get permission in the first place. This has often been in the context of news reporting with the hot news doctrine. And so there has been a sense where if you have to do something really fast, sometimes you might be able to do something without permission, and it may be more likely to be fair use because of time pressure. There's also a sense in some cases, especially more recently, that some reasons other than just information-related public interest issues are embedded in fair use. And most specifically, there's the HathiTrust case where they said disability access to materials may well be a full justification for fair use. So if there's a book and somebody who cannot hold the book or cannot read the book with their eyes needs access to it, it may be fair use to digitize the whole book so they can have it read aloud to them by a computer. So that case sort of suggests that there's public interest in copyright, in fair use, beyond just information access, although that is about information access, beyond just cultural criticism. So maybe public health is a factor that weighs in favor of fair use. We don't know. I was part of a group of library copyright specialists that put together a statement in March about fair use and emergency teaching and research. We said we think fair use is a little bit bigger right now. This is an activist position. This is an advocacy position. It's not objective at all. And so from where we stand, we were able to say that, but that doesn't necessarily mean that your organization will feel comfortable with that as well. Some organizations don't even feel comfortable allowing instructors to make fair use calls in normal times. They may require permission for everything. If they don't require permission for everything in normal times, do they want you to presume, follow your standard practices, or do they think maybe you might be able to rely on fair use a little more right now? That's maybe something to ask your organization about. Not every organization is going to be willing to go down that route, but it's something to think about. And if you want to read the statement, I'll read it aloud. The address is https://tinyurl.com tvnty3a. I'll try to remember to put the link in clickably under any video when I post this online. So that said, how do you decide whether any given use is a fair use? Well, the law says there's 4 things you have to think about, and I'm going to try to make this fairly quick. There are 4 statutory fair use factors. One of those factors, the purpose and character of your use, is about you. The other 3 are about the individual work you are using. And so sometimes people want to be able to say, well, I'm an educational user, so all of my use is okay. And that's just not going to work, because you're an educational user. Your purpose and character may be the same throughout, but the thing that you are using is, each individual book is different on these other factors. So you really do have to get to know all of these factors. First is the purpose and character of your use. Things that tend to be more likely to be fair use are educational purposes, yay, nonprofit purposes, criticism and commentary purposes. All of these tend to weigh in favor of fair use, and all of these may be applicable separately in a classroom use. Things that we know for sure weigh against fair use here is a commercial purpose. Teachers who are teaching in for-profit educational institutions may be kind of a wash on this one, I don't know. So this is kind of a tricky thing. It's not true that just because it's commercial, it's no longer fair use. They're all kind of weighing in the balance here and there. So commercial use can be fair use, but it tends not to be. Educational use sometimes isn't fair use, but it tends to be. So that's what we mean by weighing in favor, weighing against. The second factor is the nature of the copyrighted work. What are you using? It tends to be more likely to be fair use to work from published materials. That doesn't mean it's never fair use to work from unpublished materials. Scholarly biographies often quote from diaries, and that's not a problem. It's more the published works are more likely to be available for fair use. Unpublished works a little bit less likely. There's also a factor of the nature of the copyrighted work here where the courts have said, is this a more factual thing? And if you've watched the other video in this session, you will note that I said in that video, facts and pure data are not copyrightable. So if it's less likely to have super copyrightable content, it's more likely to be fair use. If it's more creative, it's less likely to be fair use. This is not actually a linear relationship, even though courts tend to talk about it like it is. Documentary films, for example, are both very creative and very factual often. So sometimes this factor is easier to understand than other times. The third factor is the amount and substantiality of the portion used, and this is the one that most people know about for fair use, why they always say, just tell me how much I can use, because the less you're copying from the original, the better. But this is also where those guidelines often go wrong, because they'll say it's always okay to copy 300 words, and more than that, you always need permission. Less than that, you never need permission. Well, that doesn't make sense at all, because it's about the portion used. 300 words from a novel is usually a tiny snapshot. 300 words from a poem might be the whole thing. So this is really problematic. Anybody who's giving those solid numbers, 30 seconds of video is okay, and more than that is never okay. That doesn't make any sense in context. You will see also people putting forth percentage guidelines. It's more likely to be fair use to use less than 10% of the work or less than 30% of the work. And there have been times when courts have suggested things like 10%. The Georgia State case is the most applicable one here. The appeals courts keep rejecting that. There is no such thing as a numeric measure of how much is okay. Less is always better, but sometimes the whole thing. And I know people like, no, it's never okay to copy the whole thing. Yeah, there are Supreme Court cases about it's okay to copy the whole thing. The Betamax case is on this topic. The Campbell versus Acuff Rose with the Two Live Crew version of Pretty Woman copies large portions. So it's okay sometimes to copy the whole thing. It's just less likely to be fair use the more you're using. The other part of the third factor is the substantiality of what you're using. So it's more likely to be fair use to use more peripheral parts of a work. It's less likely to be fair use if you're using the central portions, so key characters or climactic scenes. This one's often referred to as the heart of the work analysis. This one's quite tricky for instructors, because if you're trying to narrow down to to use the least amount, you often want to try to narrow in on the most important portions. I don't have great answers for you about how to resolve those two pieces. Use as little as you can. If you can use less central portions of the work, that may be good. But if you can't, it may still be a fair use if all of the other factors are lining up in your favor. The last factor in fair use is the effect of your use on the potential market for the original work. It is less likely to be fair use if you are harming the market for the original work, and it is more likely to be fair use if you are not harming the market for the original work. This can be a little bit tricky, because it's not just about sales of the original, it's also about licenses. So something that comes up fairly frequently and a lot right now in COVID is, I want to assign my students this textbook. It's out of print. Can I scan it for them? Well, out of print does mean that if you scan it for them, you will not be harming sales of the original book. There may be used copies to buy, but those used copies are not sales of the original book. They're sales of used copies. You won't be harming the market for sales of the original book. But if you've worked with the Copyright Clearance Center at all, or any kind of course permissions, you will know that there may sometimes be licenses sold to copy materials, even from out of print books. So sometimes this one can be a little bit hard to understand what the full potential market is. You always, if you are working with something that is currently being sold, or where you can currently go and ask them for permission and pay, it may be less likely to be fair use. On the other hand, they don't get to wipe out fair use just by saying, well, we offer a license for this. I've seen news websites where you can ask for permission to reproduce like 12 words, and they'll say, okay, well, that's $5. Here, pay $5 and you have our permission to copy these 12 words. You may well not need permission to copy those 12 words. 12 words is a very small amount of most news articles. You probably don't need that for critical purposes. Just because they're willing to sell you a license doesn't mean that that possible market harm wipes out fair use. There's another part of fair use. It's sort of a different lens on fair use that's about transformative uses. It doesn't often directly relate to teaching uses. Some teaching uses are transformative. More likely, this might come up with respect to student assignments. So this is asking, so you're copying a work or you're doing something with it that implicates the copyright rights, you're performing it in class or something. Are you doing something new with it? Are you transforming it in a socially beneficial way? And here things tend to be a little bit less about exact amounts and all of those 4 factors. Those 4 factors are still relevant, but they tend to say, well, critical things that, so critical remixes, for example, may be more likely to be fair use. Parodic or social commentary purposes may be even more likely to be fair use, may be able to, and this is where that 2 Live Crew case comes up. They transformed Orbison's Pretty Woman, and it was held to be fair use because it was a transformative version satirizing the original. This also comes up with respect to new innovative technologies. The Google Books process is actually one of the best illustrations of this. Google went out and started scanning whole books from library collections. And, you know, scanning whole books is often a little bit questionable. So they, you know, they thought this through and they said, well, we're not giving copies of the whole books to the public. We're scanning whole books to make them searchable. So we're not substituting for the original work. We're not harming the market for the original work. There was an incredibly long, drawn-out lawsuit about this, and in the end, there was a ruling that this was fair use. So fair use, transformative fair use can be really important for innovative technologies. I'm almost at the end of all of this. I don't have a slide on this last thought, but the last thought is that people sometimes feel very nervous about the idea of assessing fair use. I just told you it's like Jell-O, you're walking on Jell-O, I don't like this. And it feels like it's a very high stakes game. And there are sometimes messaging out there saying that it is a very high stakes game. You don't want to go towards fair use. Well, fair use is fairly key for lots of educational purposes. Sometimes fair use doesn't get you there. Sometimes you need to pay for your educational copies. But if you're feeling uncomfortable with the idea of just thinking about fair use, I like to point out that you do make other high stakes judgment calls on a regular basis, and even ones with legal implications. A really useful parallel is to think about if you drive a car at all, you make judgment calls all the time about how fast to drive that car. There are laws that set speed limits. There are also, as a component of almost all of those laws, there's another piece that says you have to drive within a reasonable speed range. So there may be a speed limit, but if you drive much too slowly, that's not okay, and you can actually become a traffic hazard. So there's a reasonable speed standard, and there's also, like, in reaction to weather conditions. You don't drive at the speed limit if the weather is very bad. Those are all judgment calls you're used to making. One of the reasons you're used to making them is because you keep making them. So I like to help people, if you're feeling uncomfortable with fair use, go sit down and work through the 4 fair use factors and think about transformative use for a few different uses. Try practicing, and that may well make you feel a little bit more comfortable with the idea of making these assessments. You are able to make judgment calls. You make judgment calls all the time. This is a type of judgment call that you can get more comfortable with. So that is pretty much it for making judgment calls around copyright and fair use. As I said, lots of educational uses are fair use. Lots of educational uses aren't, and you should probably be paying for those. And unfortunately, sometimes your students need to be paying for those, especially for college students. And so lots of options. Feel free to get in touch with me. I use Twitter, I use email, and, you know, University of Minnesota is a land-grant institution, so theoretically I can answer people's questions from time to time. Feel free to get in touch if you have questions. Thank you.